Welcome to a discussion regarding the criminal court process. Now, I've put this video together for those who are about to go through the process as well as their families that are going through it with them. I think it's very important that everyone be informed of the process ahead, as it is something that is probably new to many people. I'll discuss the most common court hearings in a criminal case. The typical criminal court case begins with either an arrest or a summons. A summons is served specifically for misdemeanor offenses. Arrests occur more for felony offenses, even though arrests can occur with misdemeanors as well, such as DWI and domestic violence cases. The defendant would then need to post a bond to get out of jail. The very first court date in a criminal case is called the arraignment. At this hearing, the judge will inform the defendant of the charges against him, at which point he'll be asked to enter a plea to the charges. He can either plead not guilty, guilty, no contest, also known as nolo contendere, or not guilty by reason of insanity. He can always change his not guilty plea later in the case. After he is arraigned on the charges, another court date will be issued. The next hearing is usually a pretrial conference status or motions hearing. Or, in the case of a misdemeanor, the next court date would probably be set for trial. Motions hearings may be used to discover facts and to try to figure out what will be admissible at trial against the defendant. This is also a time that your attorney and the prosecution can start negotiating in your case. After motions hearing, there are what are called status conferences or pretrial conferences. This is generally the time for all the parties, including the prosecution and the defense attorney, to get together and maybe meet with the judge and figure out how the case will be resolved or if it's going to go to trial. If a reasonable resolution cannot be obtained, then the next step is trial. Trial is the big hearing you see in movies and on TV. The prosecution must prove beyond a reasonable doubt that the defendant committed each and every element of the crime for which he's being charged. The prosecution will do this by presenting various forms of evidence and witness testimony to try to prove their case. In felony cases, the defendant has a right to a jury trial. Misdemeanors must be tried by a judge, and felonies may also be tried by a judge if the defendant chooses to waive his right to a jury trial. The final stage in a criminal court process in Louisiana is what's called sentencing. At sentencing, the judge orders the defendant to prison time or possibly complete probation and/or pay a fine, as well as other conditions. There can be agreed sentences between the defense and the prosecution. However, the judge must authorize that agreed sentence. This discussion of the criminal court process is intended to be a very general source of information. There's a lot more that goes into it than just this, but this is a good starting point. If you need me to represent you or someone you know, feel free to give me a call. I'd be happy to help.